Good afternoon, everyone. I'd like to welcome you to the Cook County Board of Commissioners special meeting today, Tuesday, August 6th at 1 p.m. And we are here to learn a little bit about the proposed cannabis ordinance. To give the public a bit of background, and for those of you that are here, the purpose of this opportunity is to gain knowledge and insight about the work of our Cannabis Committee, learn more about the proposed ordinance, and to get feedback and input that you have as citizens. And I'll be taking a number of notes over the next hour or so as we collect that feedback and input. In order to enhance participation for this process, there is going to be a public hearing at 4 p.m. There is another town hall next Monday on August 12th at the ACA at 4:30 p.m. And we're also asking citizens to leave feedback on an online written comment piece on our county website, and also they can leave a voicemail on a dedicated phone line that we have set up to collect information. Just as background, obviously cannabis was illegal in Minnesota and throughout much of our nation for many years, but medical marijuana has legally been available in our state since 2015, and there are 9 different medical conditions that it is available for treatment for. It's considered the most restrictive medical marijuana bill in the United States at this time. A couple of years ago, food and beverages containing THC became legal in our state, and that was if the chemical was derived from hemp. Packages were limited to a THC content of 50 milligrams total and 5 milligrams per serving. And these are the products that we have, beverages and gummies, that you can currently purchase at 13 different locations in Cook County, like the Co-op, Holiday, Trail Center, a variety of other places. Cannabis became legal in Minnesota a little over a year ago on August 1st of 2023, and legalized was the use, possession, and the cultivation, with some laws taking effect right away and then having an Office of Cannabis Management established to enact further legislation. Minnesota law permits adults who are 21 and older to purchase and possess marijuana flower, concentrate, and edibles. And growing at home is permitted as long as the plants cannot be seen from the outside, and an individual can cultivate up to 8 plants with 4 of them flowering at a time, which is considered maturity for that plant. The bill that passed a year ago also removed all penalties for cannabis possession and results in the expungement of all previous criminal convictions for the first time in subsequent cannabis possession offenses. And since the state of Minnesota will begin awarding general licenses for sale of cannabis in January, and later this month will begin with their social equity applicants, some guardrails might be appropriate to have in place in the very near future. Sheriff Eliason and Attorney Hicken have been co-chairs of a 2-year committee established to discuss the creation of an ordinance and to regulate business and underage use. And in addition to that, they've had great representation on that committee. Some of you are here today who sat on the committee. We had representatives from Public Health and Human Services, the School District ISD 166, the City of Grand Marais, the Cook County Chamber of Commerce, the County Board, general citizens, and the Grand Portage Band was invited as well. So with that background, I will turn the overview of the proposed ordinance to Attorney Hicken.
Thank you, Madam Chair. So I have a PowerPoint which I've provided to Jana. Yes, I would love the clicker. This is this took me, how long did this take me to go through it at the town hall yesterday? 45 minutes. I'm going to actually zoom through parts of this PowerPoint a little faster. In this setting, I'll talk a little less about the formation of the Cannabis Regulation Committee, since you know about that already. But what I do want to cover, ready when you are, Jana. What I do want to cover is, what is the current state of the state law on cannabis? Because what the state has done is has critical impact on what we can do as a county to further regulate or control use and sales of cannabis in our jurisdiction. And then I'll go through what I see as kind of the major parts of the ordinance. We can also display the ordinance and talk about specific language if commissioners or members of the public are interested. So let's just get into it. I already talked about what we're going to do. Cannabis Regulation Committee has met on 3 occasions, solid 90-minute to 2-hour long meetings. It's a really engaged group. The composition of the committee is listed on this slide. It's diverse. We attempted to include all the stakeholders that we thought might be impacted by any cannabis regulation or by the state's new, more liberal controls around cannabis. But I do have to say that the recommendations that turned into the ordinance, the proposed ordinance for commissioners, are not really based on consensus of the committee because the opinions were so variable. And I would say the biggest reflection onto the ordinance here are the opinions of public health, of myself as a prosecutor, and of the business community representatives. There was a lot of agreement, but we didn't have a vote. I just want to make sure that's known. We didn't vote on this ordinance to pass this ordinance on to the commissioners. This is really an amalgam of a lot of our discussions and then combined with my recommendations. We do have, I think, just one member of the Cannabis Regulation Committee here, and that's Grace Granager. She's in the audience. So, Madam Chair, if it's okay with you, I would invite Grace to interrupt me when she sees something valuable to add, or correct me when I get something wrong. Please.
And Grace, if you'd like to come up and sit by a microphone to make that a little more understandable for our listeners out in the live stream, can have you do that.
We did do some polling of the committee and identified some top priorities. And not all of these are related to an ordinance, but more related to the ongoing work of the committee. We did think that it was important to be able to track the impacts of adult recreational cannabis use in the county. It's new in the, I mean, there are other states who have legalized it, but not in the way that Minnesota has legalized it. There isn't a lot of there aren't long-term studies on cannabis impacts on youth, for example, or law enforcement, because it has been scheduled at such a serious schedule under federal law for so long. So we'll be working to pick some metrics that we can kind of track along over the next year. Also, we see it as a mission of the committee to educate the public on those impacts and on the state of the law in general and what our recommendations are. It's a priority of the committee to allow for local business development for producers and retailers of cannabis products because the state has made this a new business opportunity and it's not an option for the county to prohibit cannabis businesses from existing in the county. So it's a business opportunity. And finally, one of the things close to my heart is to reduce the proliferation of cannabis products among youth and in the schools. We do have Chris Lindholm, the superintendent, is part of our committee, and we're going to hear from a subcommittee next week at our meeting next week on some recommendations and the known impacts on youth of cannabis use. So the state cannabis law was passed in 2023 with modifications in 2024 legislation. As of August 1st last year, it became legal for those over the age of 21 to use cannabis. It is not yet legal to sell cannabis in the state other than under the medical marijuana law. It was the observation of our committee members. We haven't seen a lot of change in our community due to the use, and that did help to contribute to our recommendation or I guess our lack of a recommendation to prohibit public use. We're not seeing that there's been a great change in the events, or and obviously people might have different opinions about that we're willing to hear.
I will interrupt you quickly.
Yeah.
This is to say that the city of Grand Marais does have the public use ordinance. So it's not in this draft ordinance, but it is in the city's.
That's a great clarification. Thank you. Obviously, the city has different jurisdiction than the county. We're not recommending that the county take on a public use prohibition. And that is due also in part to the fact that the city has done that in a zone or a couple zones of the city in what's probably the busiest part of the county at our busiest times. So since they've done it, that's one more reason that maybe we don't need to do it. So the statute creates the Office of Cannabis Management. It creates a taxing structure so that 10% of gross receipts for cannabis retail operations will go into a tax coffer, and that those funds will be split 80-20 between the state and local governments. That's all we know basically right now about the money that will come to local government. We don't know whether it's going to be restricted in its uses. There is some information out there about how the number of businesses operating in a county might impact the funds that come to that county from the local government aid fund. But it is a fact that 20% is reserved for counties in some way, counties and local governments. A big part of the new law is to create the state licensing structure for cannabis business development. We'll talk about the various types of licenses that the state will be issuing in 2025. There's also expungement of prior convictions for marijuana-related crimes that has gone into effect. Every law enforcement agency and prosecution agency in the state has had to collect the files they have from past cases where people were convicted of or arrested for cannabis-related crimes, and has had to seal or expunge those records. And then there's some temporary regulations of the hemp THC edibles. We'll talk more about what that means. And finally, marijuana has been rescheduled under the state law from Schedule 1, a more serious schedule, to Schedule 3, which is a reduction in the restrictions of use of this product. I'm not going to dwell too much on definitions. I just want you to pay attention to this. There's cannabis flower, which is maybe what we thought of as marijuana in the 70s and the 60s, the plant. There's cannabis concentrate, so these are the resins or oils that are extracted from the plant. They're going to be more potent typically than the flower. And a cannabis product. A cannabis product is going to include a concentrate or a product that is infused, often a food type product, and any other product that contains cannabis concentrate. So these are the edible cannabis products, the beverages, the medical cannabis products. It does not include the flower itself, though.
I'll jump in on this too, because alongside all these definitions, one of the things we do know about cannabis, and this is not part of legalization, but it's happened on the side over the past 20 years. One of the trends we've seen with cannabis, regardless of whether you're in a state where it's legal or not, is that the potency of cannabis products has risen dramatically. And so it's not uniform across these different products, but in general, the cannabis products that are available in the world now are much more potent, and there's a wider variety of potency to the products. And so from a prevention standpoint, and we talk about use and education, that really does play into it pretty heavily. We're not talking about one product, we're talking about a whole family or a whole range of products that has different effects depending on the potency and the person consuming it.
Yeah. So I guess we should be careful when we compare the marijuana of today to the marijuana of the 70s and the 60s, because it's a very, in most cases, a very different effect or impact on the user. We are going to touch on lower potency hemp edibles. These are products intended to be eaten or consumed as a beverage, but they are hemp derived. They include THC or cannabinoids that are hemp derived rather than the marijuana plant derived. And that is why they kind of became legal and wound up on our shelves much earlier. These are for sale in 13 different businesses in Cook County, and we know that because you can go to the state website and you can search the registrations. One of the things that the law created is a registration system and the requirement that any business selling these lower potency hemp edibles is required to register with the state. And there, I understand there could be licensing coming up also for those businesses. But these, by definition, are lower potency than the cannabis products, the cannabis concentrate and the cannabis flower. They are limited to 5 milligrams per serving of THC or CBD, and they are on the shelves. They, we'll talk a little bit about how they are on the shelves and like what are the requirements around them. Just a bit of information about the Office of Cannabis Management. This is this new state agency created by the statute. 342 is the statute chapter. And they are putting out a lot of the guidance for local governments right now. Our ordinance, our proposed ordinance, is based on the model ordinance that they published. So as I mentioned, OCM, or the Office of Cannabis Management, is the licensing authority created by the statute. Counties don't license, cities don't license. The state has exclusive authority to license cannabis, the cannabis industry in general. And the state has also created lots of operational requirements for how those businesses are set up, what they look like, their security. There are rules about who gets to enter. For example, cannabis retailing businesses, they don't get to allow anyone under the age of 21 into their doors. They can't hire employees or contractors under the age of 21 who have any involvement with cannabis. And there are also operational requirements in state law that have to do with the labeling and placement of those cannabis products. For example, they've got to be in child-proof packaging. They have to be labeled for 21 and over. They have to show serving sizes. They have to have testing information on their potency. So I mentioned there are a lot of different types of businesses the OCM is going to be licensing. This is the entire list. What's important for us to know as the county is that the state has exclusive jurisdiction over licensing all of these and has only given a bit of authority to the counties to require a local registration for some of these licenses. Those include those top two, micro business and meso business. These are businesses that actually produce the plant or the product. And if they have a retailer endorsement, then we can require that they have a county registration. And also, about 6 bullet points down, the cannabis retailers. So these are the stores that just buy from a wholesaler and put the items on the shelf and retail, sell them out. So those are the only 3 types of businesses that our county ordinance is allowed to regulate. The rest of them are exclusively up to the state. And you can see it's an interesting combination of types of businesses, including cannabis event organizers, cannabis delivery services. So this is the part, permissible possession of cannabis. We'll talk about what the law permits as far as possession, what the state law permits as far as use of cannabis, and then we'll talk about what's what is prohibited to possess and prohibited to use. So we've already talked about it. 21 and over you must be in order to possess cannabis legally under the state law. You may actually possess up to 2 pounds of cannabis in your own residence. That's a lot, if you don't know. That is quite a bit. I would say plenty for personal use. You can possess up to 2 ounces of the flower in public. And then for each of these amounts, there's a different amount for the concentrate and a different amount for the THC infused edibles. It gets lower every time because of the potency. So up to 8 grams of the concentrate you can have in your possession, and up to 800 milligrams of the THC infused edible products. Cannabis paraphernalia is legalized. That used to be something that the sheriff's office could issue a ticket for, drug paraphernalia. Now that is not on the table anymore. It is legal to give away cannabis to another person, as long as you're under these amounts and as long as that person is over 21. And then it's legal for an individual to cultivate products for their own use. Commissioner Sullivan already kind of summarized the plant rule. If you're going to cultivate at your home, there must be at least one person over the age of 21 who is a primary resident there, and it must be in an enclosed and locked space not open to public view. So those plants can be outside, but they can't be, you can't see them from the sidewalk, and they have to be locked and enclosed. Permissible use. So we talked about possession. Now we're talking about use. Actually consuming that product. Have to be 21 and over. You can do it in a private residence, including your yard, including your curtilage. Curtilage is a legal term. I'm not going to even try to describe the definition to you, but let's say it's that space in your yard where somebody might walk up the driveway and drop something in your mailbox. That's your curtilage. It's technically your private property, but members of the public often use and access that property, or that part of your property. That's your curtilage. So folks can use cannabis on their own property. They can also use cannabis on other people's private property, so long as they haven't been explicitly prohibited by the property owner to do so. And then they can also use at an establishment or at an event that's licensed to allow for on-site consumption. Here's what's not allowed related to possession. If you're under 21, obviously no. No possession at a public or charter school or in any school-used, school-owned vehicle or building. No possession at a state correctional facility. I'm just going to intervene here with a picture to let you kind of wrap your mind around how much these amounts are. Remember, and these are, they're bigger than real life, okay, on that screen, obviously. A single bud, a gram of marijuana is going to fit in the middle of the palm of your hand. And then it goes up from there, an eighth or a quarter. These are eighth or quarter ounces. Those are common selling amounts. A half ounce is that picture in the middle row on the right, and then 1 ounce is that pile of flower buds on the bottom, or 28 grams. Remember, you can have up to 2 ounces on your person under the new law in a public space without being in violation of the law. And then, as somebody at our town hall last night pointed out, 2 pounds is about 32 times 1 ounce. You have 32 times that amount on your person at your house. Oh, and should talk about the right side of this slide too. When we're talking about the criminal penalties for possession that's unlawful, the state got rid of repealed a bunch of laws which made marijuana possession illegal, and they replaced them with these laws. When they did so, they said it's unlawful for a person under the age of 21 to use this product. They did not assign a criminal penalty for everyone, though. They said adults under the age of 21 are going to be guilty of a misdemeanor, or I think it's a petty misdemeanor, for possession of less than 2 ounces. They did not assign a criminal penalty or any penalty for kids, the under 18 crowd. They said it's not lawful to possess it, but they didn't say, and here's the penalty. So that makes it difficult for a prosecutor to hold a child accountable, and there are reasons that they intentionally did that. And you know, a lot of I think that the philosophy of some legislators is that we don't want to criminalize kids, we don't want to throw kids in jail. But when they did that, what they did is they limited the opportunities to intervene on a child who might really require intervention because of their chemical use. So we'll talk about what I added into the ordinance to try to fill that gap. Prohibited use. Can't use if you're under 21, obviously. Now pay attention to this because it was in part because of these state rules around use that we decided not to recommend to the county that we have a prohibition on public use, because the state already regulates use in many different ways. Primarily, you can't smoke or vape cannabis in a location where a minor could inhale that vapor. That's an important one. You can't smoke or vape the product or any cannabis in a public place that would be where it would be in violation of the Clean Air Act to smoke a cigarette. So not in the courthouse, not on the steps of the courthouse, not in public transportation, not at a public meeting, not in a place of employment. So that is really kind of narrowing more the types of public places where somebody could smoke the product. Now, we did consider whether the county would like to prohibit use of the non-smoked product, so the edible products, the tinctures and the concentrates that are consumed without smoking. And we talked about that, and we kind of turned down that option because of enforcement. How does one enforce, how is the sheriff's office going to enforce somebody who's eaten a gummy downtown? They would have to catch them in the act. And once it's in their mouth and in their stomach, how are you going to prove the contents of that it was an illegal substance to? So enforcement would really be an issue if we were going to try to prohibit the use of those edible products in a public space. Can't use at a school, on school property or correctional facility, just like you can't possess there, you can't use it. You cannot drive a motor vehicle while impaired by the use of these products. Also, no one in the car, including the passengers, can use the products. You can't smoke it, you can't ingest it, not even the low potency edibles are you supposed to be allowing your passengers to ingest while you're in a motor vehicle. You can't give those products to anyone under the age of 21. And businesses that sell goods and services are not allowed to give cannabis as a promotional gift. So watch out for that. I feel like there's a business in Duluth that might be in violation of that, but maybe those are hemp-derived products. Okay. So here's what we can't do. I'm going to talk first about what we can't do as the county. What the state law says is we can't prohibit the possession, use, or transport of any cannabis where the state has said you can do it. That makes sense, right? We can't conflict directly with state law. We cannot prohibit the establishment of any cannabis business that's licensed under state law, with a caveat in my next slide. So if a business has a state license to sell cannabis, we can't say, not in Cook County. But we can, in our next slide, we can regulate the time, place, and manner of cannabis retail businesses. So we can direct, to a certain extent, when, where, and how they sell cannabis. We can require a county registration on top of that state license in order to do business in the county. And we can limit the number of county registrations that we issue. We can create new zoning regulations, or we can regulate the zoning of cannabis businesses, including creating buffer zones around daycares, schools, playgrounds, athletic fields, places where youth might frequent. That's not in the state law, but the state law does allow locals to do that. We can prohibit in public places. We've talked about that a couple times. We can adopt regulations related to cannabis events occurring in our county. And we can enact more stringent measures regarding secondhand smoke or involuntary exposure to the aerosol or vapor from the electronic delivery devices. Now, I put an asterisk on that we can limit the number of registrations the county issues. The thing to bear in mind about that is the city also has its own authority to set up a registration structure by ordinance. They haven't done so at this point yet. They're interested to see what the county passes. But should the city council decide to pass an ordinance requiring city registration, then they get to control what happens in the city. They can disregard the limit that we've put on the county, and they can create their own limit or have no limit at all. That's their option. Okay. Now we can talk about the ordinance finally. Here are the basics. We have proposed in this ordinance that the county require a registration for any state licensed business to do their business here. It includes an application, a $500 initial registration fee. They have to say where in the county this is going to happen, including the parcel ID. They need to certify that they're in compliance with all local ordinances. So you can't get a registration if you don't have the septic system you need, or if you have another type of ordinance violation. You got to be, whoever owns the property that your business is going on has to be current on property taxes, and we've also included an insurance requirement. So these businesses have to be adequately insured with commercial liability insurance. Okay, and because we've proposed the registration system, we are also taking on the authority and the responsibility to do annual compliance checks of those businesses. If we weren't to require a registration, then we would not have this responsibility. So you need to know that that's an additional burden we take on once we put up the registration system, and that the state kind of directs exactly how those compliance checks happen. In our ordinance, we have proposed that the auditor's office issue the registrations, that public health conduct the compliance checks, and that the sheriff's office and the county attorney's office enforce the ordinance. So those are the county departments that are impacted by this proposed ordinance. The compliance checks need to include age compliance, so unannounced visits by people who are 17 to 20 and trying to buy products, kind of sting operations. Operational compliance checks, so we're checking for, again, are the products properly labeled? Is the security up to snuff? Are they checking IDs when allowing people into the store? And then our ordinance allows us to suspend a violation, or suspend a registration for a violation, which is going to mean they can't operate in the county. We can issue a civil penalty up to $2,000 under the ordinance for violation of the registration. Okay, the other thing about registrations that's in section 2.6 here is that we're limiting the number of registrations we issue. We've picked the number 14, and it's going to be up to the commissioners what number you think is appropriate, but I can tell you how we came up with that recommendation. And this effectively limits the number of cannabis retailer businesses that can operate in the county. Again, remember, we don't have the authority to limit the number of the producers, the cultivators, the cannabis delivery services. We can only limit cannabis retail businesses. So there was some agreement in the committee that if we're going to regulate cannabis, we ought to regulate it similar to how we regulate alcohol. Also, alcohol is an addictive substance. Alcohol is something we restrict for younger people. If we're going to pick a regulation structure, maybe we make it similar to alcohol. Not only are the substances similar, I guess, in their psychoactive effects, but also if the regulation is similar, then it makes enforcement easier. We don't have a whole different set of rules for one substance than we do for another substance. And we're always having to think about how are we going to enforce whatever we put into place here. So here's what the alcohol ordinance, the county's alcohol ordinance does related to off-sale liquor stores. It says you can have exactly one in each of 7 different regional spaces. You can have one in the city, you can have one in each organized township, and as a reminder, we have 3 of those. They're all on the west end. It's Lutzen, Tofte, and Schroeder. You could have one in each of 3 unorganized areas, which are referred to in general as the Gunflint area, the Lutzen area, and the Hovland Grand Portage area. Grand Portage came up here in this slide. That does not mean we have jurisdiction over what happens in the reservation. We're talking about the unorganized territory around the reservation. Grand Portage is a sovereign nation. They have exclusive jurisdiction to regulate business on the reservation. So our ordinance does not impact activities on the reservation. But in our ordinance, so I said 1 liquor store per each of those regions. We chose 2 cannabis businesses. And the reason is, remember I talked about the 3 types of licenses that can be impacted by our ordinance. There's the purely retail businesses, those that just sell the product off the shelf that they got from a wholesaler. And then there's micro businesses and mezzo businesses with a retail endorsement. So these are stores it's a store that sells a product that they make themselves. So they're both producing the product and they're selling it. It was the thought of the business representatives on the committee that we should allow an opportunity for both types. So, for example, in the Lutzen area, we have an off-sale liquor store where you can buy a product off the shelf and walk out with it. We also have the winery where they make the wine and they sell it. You can walk away with a bottle. So the idea was to provide that same kind of an opportunity. Again, these are purely recommendations, and it's up to commissioners as to how and where we allow these businesses to be registered. I'm going to take a breath. Does anyone have any questions so far?
Yeah.
Commissioner Storley.
Yes, thank you. So as far as the number of registrations go, is that looked at per year, or when we set the registrations for 2025, is that set in stone?
When we set the number of registrations we allow in the county, we're sending a signal to the state that they can't issue more licenses for Cook County cannabis businesses than we have set up, than we have allowed in our ordinance. We can always amend our ordinance. Once businesses are established, say that 14 businesses establish themselves in these different zones, It's going to be difficult to go backwards and to say, okay, 7 businesses need to shut down now. Obviously, those business owners put a big investment into their properties and their businesses, and the county's going to open itself up for liability when they choose which businesses get shut down. It would be more practical to expand the limit than it would be to shrink it, if that makes sense.
Well, the reason I ask is that we can learn from other states who have been in this business a lot longer. And what has happened is that there are companies who do cannabis who come into new states to get licenses. And that's what I would like to prevent. So if we have pretty much all of our area covered, I don't know then legally if they can go to the state, this company from wherever, and say, we'd like to establish another business in Cook County at the county line or something, where we haven't covered anything.
This covers the entire county. So we're saying 14 total, and we're saying the registrations that are issued have to be in these zones.
I'll add one more thing to
Yeah.
know about what the state has said is there's a population basis for the number that is required. So if there were to be a municipal cannabis retail business, we would still have to have at least one because it's limited per population. So it's
At least
one
one
per,
additional.
one per 12,500 people. And since we have fewer than 12,500 people, one. And then if there were to be a municipal, that could not be the one. So there would in that case be 2. So that's the lower limit that the state has set for us. So we couldn't say 0 or only one that would be municipal. That's the kind of lower limit. So this ordinance, what's in the draft ordinance is higher than that, and it's set up like Attorney Hickens said, to mirror the alcohol zones. But again, that's ultimately going to be the board's decision. But that's another piece to just keep in mind, that that is what the state has set as a floor.
Okay. Anything else? All right. I'm almost.
I'll save it.
Okay. Almost done. I want to leave us plenty of time to talk. Buffers, we did set up the buffer zones in the ordinance that's proposed for commissioners. The buffer zone is 500 feet. That's the maximum we can allow under the state law. And it affects businesses within 500, proposed businesses within 500 feet of a school, a daycare, a residential treatment facility. We don't have any of those yet. And, or within a public park regularly used by minors and including a playground or athletic field. This also, the other part of this is that if a business is already established and a daycare were to open up within 500 feet, that established business, we can't require that established business to then move. But we can prevent businesses from being established within already existing buffers. We've got our GIS professional and Tim Nelson are working on creating a map which can show the zones around which, or within which these businesses can't be established. Real quick, these are commercial businesses, so they have the same zoning requirements as any other commercial business. So we've outlined the commercial zones that where these can be placed, and we've also outlined in the next section the zones where this may be a permitted use with a conditional use permit or an interim use permit. We've also limited hours of operation from 10 a.m. to 10 p.m. The maximum, so without any modification by county ordinance, these products could, or these stores could be open and selling from 8 a.m. to 2 a.m. So we did decide to limit hours of operation. Advertising, in the state law, it already says you can only have 2 fixed signs outdoor advertising, 2 fixed signs on cannabis retailing businesses. So we just mimicked that in our county ordinance. Lower potency edibles, these are restrictions that, well, this first one, lower potency edibles have to be in a locked case or behind a checkout counter. That's already in state law. We added to that. We said also they have to be at least 1 foot separated from conventional candy and gum that a child could purchase and consume. And we also added restrictions for placement of the hemp beverages because those are not regulated. The placement is not regulated. So, for example, at a local convenience store, there are 2 registers. There's an open cooler between those 2 registers. It's right at kid height, and you can reach in and get yourself a bottle of water, or you can reach in and get yourself a THC beverage. We're saying no. We're asking business owners to put some investment in and make these products less theft, so that they're more protected. The language is must be stored in a location or using a method which provides increased theft prevention compared to non-hemp derived products. For example, top shelved, continuously surveilled by technology or staff, or behind a counter and locked. And then we're asking them to clearly label the cooler or the area of the cooler that says this is only for consumption by people 21 and over to avoid confusion. And the same advertising regulation on the cannabis products, we're also asking for these regular stores, gas stations, grocery stores that sell the lower potency products. They also can't advertise outside their store with more than 2 fixed signs. And if they're going to advertise and market those products inside their store, they got to be above kid height, above 3 feet, so that you don't have small children who are passively exposed to the marketing of THC and hemp beverages. Okay, here are the prohibited acts by underage persons. Remember, I said I'd like to establish a penalty for a few different reasons. One is to enable the courts to intervene in the case where what this says is your first 2 offenses as a person under the age of 21 using, possessing, or transporting cannabis are petty misdemeanors, like a traffic ticket. You could have a probation officer, or you could be ordered to do an evaluation, but you can't be ordered into juvenile detention. But the 3rd time you violate, that's when you're going to be charged with a misdemeanor, and a court could have that option of putting a child in residential treatment, which is technically an out-of-home placement, or into a detention center. We're always going to go, at least in this jurisdiction under my leadership, we're always going to try treatment where it's necessary. And then also there's a petty misdemeanor created for any person who's using a form of false identification or somebody else's ID to attempt to purchase these products. We got that from our under 21 tobacco ordinance that the county passed a few years ago. Okay, one commissioner did request that we put section 7 or keep section 7 into the proposed ordinance. This is the enabling language to allow Cook County or the city of Grand Marais, and the city of Grand Marais if they wish, to establish, own, and operate one municipal cannabis retail business. So a government acting as the cannabis retailer. Like I said, this enables it under the law. This does not set up a new department or fund the operation or hire any employees. Those are separate decisions that these governments would have to make. But this opens up the possibility in the future that they could do that without having to pass an amendment to the ordinance. I'm gonna just go ahead to, here's your other opportunities for public feedback. So, okay, Madam Chair, thanks for your patience.
Absolutely. Do commissioners have any questions at this time?
Yeah, I would just like
Commissioner Johnson.
clarification about registration versus licensure. So the state gets to license. You have to go there first and get a license. If can one person get 14 licenses for Cook County then, if we say there's 14?
Can you say that one more time?
The licensure at the state level, thinking about what Commissioner Starley said about these companies coming in. Can a company come in and apply for all 14 licenses for Cook County under this ordinance?
I don't see a restriction
Okay.
against that.
And then we're talking about the two different ways, like off sale versus the
Oh, yeah.
winery.
Uh-huh.
Are we saying 7 are going to be one way and 7 are another way, or are they all 14 going to be wineries?
Good question. No, we're not reserving one per region for each type
Okay.
of those businesses. Right.
I just want to clarify what we're looking at.
I can, I'm just on the OCM website, so here's what it's saying, okay, so at first, this is all through a lottery system, but that's at first. So long-term, I'm not sure. But at first, there's this lottery. And so a retailer, for initial licenses, and they're separated out by business type. So for the retailer specifically, a cannabis retailer may operate up to 5 retail locations. However, no person or business may hold a license to own or operate more than 1 cannabis retail business in 1 city and 3 retail businesses in 1 county.
Oh, 3. 3 is, okay.
So it sounds like we don't have that restriction in our registration ordinance, but the state does have that restriction in licensing.
The website is informative. They keep adding to it.
Yes, changes.
Every time I look at it, there's more content, so.
Any other commissioners have questions at this time? Commissioner
Other than
Sterling.
just verifying, is this PowerPoint going to be on the website then for people to look up in the county?
I can put it on the website, yes.
Okay. And is it the same that we have here, only in a different form? Or should we also have this to review?
You're talking about the ordinance itself?
When you
Or-
did the PowerPoint,
Yeah.
is this the same as what we have here?
No.
No, okay.
It
Could
is
we
not.
also
One is
have
the
that?
ordinance and one is
Yeah.
just the PowerPoint for the
Yeah.
public.
Oh, you're looking for
The
a
PowerPoint.
printed?
Mhm, yeah.
Yes,
Yeah.
we can print it.
Okay.
I'll ask staff to do that right now, actually.
I think those of us who aren't here, and we need all the information we can get, plus go to the website too, because that's an updating almost every day, it seems.
Correct. Commissioner Johnson.
Yeah, I'm still on the registrations. And how did you come up with the amounts for these? $500 and a renewal is $1,000? I'm just wondering where that came from.
Those are the maximum allowed under the state statute. And they were in the model ordinance. We stayed with them because we're hoping to partially fund the resources it'll take for the county to administer the ordinance and enforce it.
So it is at the top level?
Mhm.
Okay, that's what I
Yeah.
want to know, thanks.
Yep, the maximum for the initial registration is 500 and the maximum for a renewal is 1,000.
And I'll add that's in addition to the licensing fee. So the licensing fee is, for the state, is $2,500 for the application, just to apply to be in the lottery. But then if you're chosen in the lottery, the actual initial license fee is an additional $2,500. And for a renewal, I'm not sure how often the renewal happens, but the renewal is $5,000 for the state. So that's outside of
Okay,
ours completely. That's all with the Office of Cannabis Management.
thanks.
Any additional questions before we open it up for a public hearing? All right. Well, our public hearing today is an opportunity for us to receive public comment. And there has been a notice of the intention to consider this ordinance to regulate cannabis businesses and underage cannabis possession. We had that in the Cook County News Herald, which is our official newspaper. And a draft of the ordinance is on file at the county auditor's office where people could look at it. It's also on our county website. And so are there any members of the public that wish to speak today? And Mike, if you could come forward and sign in on the sign-in sheet.
I would be glad to.
Thank you.
I'm Michael Carlson, live in Crossville, Highway 61. Just a couple of things that came up recently. The 6.1 issue about 2 ounces or less seems to be backwards. You're saying that they're restricted to 2 ounces or less. It means that 1/100th of a gram would still be a violation. It probably should say 2 ounces or more. In both 6A, 6.1A, and 6.1B. I'm pretty sure I got that right.
Madam Chair, do you want me to respond now? or-
Please, if you would.
Okay. So what was on a slide but I didn't say out loud is that the state has created criminal penalties for the possession of 2 ounces or more than 2 ounces in public by any person, no matter what age. It's the levels below 1 or below 2 ounces that there is no criminal penalty established. So that's why in our ordinance, we're only focusing on less than 2 ounces. If I understand your question, Mr. Carlson, that's why we're focusing on less than 2 ounces, because we do have that tool of the state law that asserts a penalty for more than 2 ounces. But I'm going to open up the ordinance here, which I should have already had open, and make sure that I'm not.
Yeah,
stepping out of there.
6.1A says 2 ounces or less of cannabis flower. So it is, in
Yes.
my estimation, written correctly given the state law.
Yeah, so that is intentional.
So what that says is that any amount whatsoever, even 1/100th of a gram, would still be a violation.
Yes, a petty
Okay.
misdemeanor for the
All
first
right.
offense. Yep.
Other question I have is about the signs. Is there any limitation of the height of the signs, whether they be electronic, whether they could be visible 24 hours a day, or just during opening hours? I saw nothing about size, height, electronics, or does the county ordinance already cover that?
So the county sign ordinance is still active and applies in addition to these sign requirements. So whatever we have in the county ordinance is going to also regulate any of these signs.
So this could not be more restrictive than the county ordinance?
It would be more restrictive in that we are limiting the number of signs to 2. Although I haven't looked at the county sign ordinance in a while, so I better look at it. Good question.
Doing the same. It's ordinance number 53.
Then my last question is 6.3, and this is the municipal store shall not be included in any limitation. It sounds to me like the municipal store could be the 15th store under that
Yep.
consideration. Am
That
I
is
correct in believing that?
That's correct, and that's consistent with the state law. The state law says if the county's going to create a limit of registrations, then any municipally owned retail business would not fall under, would not be affected by that limit.
So one more comment on 6.1. I think you would be much clearer to say on 6.1, any amount of cannabis flower, and likewise, any amount of concentrate. It would be much clearer from a mathematician's point of view.
Thank you. What I would be afraid of if I did that is that it would cause confusion, because if there is 2 ounces or greater, it's actually going to be a higher penalty under state law over 2 ounces.
Yeah,
Yeah.
yeah, it's just, I think it's pretty hard to interpret the way you have it here.
Okay. Thank you.
That's my opinion. All right, thank you.
We appreciate that. Thank you. Are there other members of the public that wish to speak today? Any other members of the public who wish to speak? All right, well, at this time, I'd like to remind people who are listening in, as well as those people who are here, that we would really encourage you to provide feedback after this public hearing as a written comment on our website, or you can call and leave a voicemail at 218-264-1094. And the opportunity to provide comments will go through the rest of this week and next Monday as well. And with that, we are adjourned. Thank you very much.